I want to tell you that approximately 2 or 3 months ago, Leslie Borgnani, who serves on our CJA panel, asked me, why was I moderating this panel? And I told her I did not know, because we don't handle domestic violence types of cases in the federal system for the most part. And she said she was going to come just to see what I do, and she didn't show up. Let me say this. This morning,
I talked to Ms. Borgnani this morning, and she broke her foot, and so she had a doctor's appointment today. So that is her excuse.
oh, very good. I will tell you though, let me say this. I asked Judge Volpe to send me all the information so I could get prepared for the day. And I didn't know what would happen. I had this morning a revocation hearing. And as you would probably imagine, what were the issues in the revocation? It was a man who had been charged and found guilty of being a felon in possession of a firearm. And so I came into the hearing today, read the petition, and this is what it said. It said one of the allegations was that he, on February the 19th of 2023, Mr. Defendant allegedly pulled Mrs. Victim out of a vehicle to the ground and struck her. After which the victim ran inside a gas station. The defendant allegedly followed the victim into the gas station and forced her to the ground, striking and kicking her repeatedly. The victim went back to the vehicle where the defendant struck her again and drug her out of the vehicle, ripping her shirt and bra. The defendant was arrested. And I will say this, when I read that, I started thinking about all of the cases I've had over the years where people were brought back up for revocation in domestic violence cases. And so I guess the federal court doesn't see it on the front end for the most part. We see it on the back end. And I just want to see a show of hands. Anybody here who's seen that case before? Yeah, many of us have. Either personally, we know people who've been the victims of domestic violence. We know people who've come to us and said they've been accused of being the perpetrators of domestic violence and they didn't do it. Or we've had cases where we've been around it. So the Power Act itself was adopted for the purpose to encourage people or lawyers to provide pro bono services to victims of domestic violence and sexual abuse. And so that's why we're here. And the discussion we just heard was about filling out orders of protection or receiving orders of protection. But what we want to talk about now is what judges face and how you all, we want to encourage you to help people who are involved in domestic violence situations and encourage your fellow lawyers to do the same. My first question is to the panel, and I'm going to start with Judge Whatley and then Judge Johnson. We've heard a lot about domestic violence. We've heard a lot about orders of protection. And I think we've heard a lot about all the intricacies of that. But what makes domestic violence cases unique from your perspective? What makes them different than the average case? I know I have my point of view and I might come in on the back end, but what is your position, Judge Wiley?
So the biggest problem that I see with domestic violence cases, especially in my court, I have a 100% criminal court, so mine will be different than Judge Johnson's. My issue is getting the victims to actually cooperate with the prosecutors or come to court and testify. That's the biggest issue that we have. And it's so often the state's having to ask for a continuance because they haven't been able to get the victim in, or they're having to null pros a case because they can't make the case without having the victim's testimony and they can't get the victim there. I did talk to one of our prosecutors this morning who half of her docket is domestic violence. And she says that one of the biggest problems they have is being able to get in contact and have updated contact information for the victims, because the victims are changing their address, they're changing their telephone number about every month. And then they don't think, oh, wait, I need to get in touch with Ms. Johnston to let her know that I have a new number, and they're not showing up to court. And that's the biggest issue that we face in criminal court.
Okay, Judge Johnson.
I see several issues, and of course, my docket is 50% domestic relations and 50% probate. And so I see petitions for orders of protection on a weekly, sometimes even daily basis. And I'll say, and this is kind of bracket this, I think the process does get misused because it's a summary process. And so we will see a lot of petitions for orders of protection where someone's just trying to evict someone else, or someone's posting ugly stuff about them on social media. But that is not, when it comes to actual violence between intimate partners or family members, the issues that I'm often seeing in those cases are going to be, or the biggest challenges I'm seeing are cases where the parties share children. Because orders of protection and that process is really a very expedited process. When the parties do share children, it's even though the statute authorizes it, it's very difficult to deal with custody, visitation, child support, alimony, the things that they're authorized with the statute, because there's oftentimes not sufficient time on the docket to deal with that. And, related to that is the joint custody law that was enacted in 2021. Well, I think that is, and I mean, joint custody is, and I think really should be the standard in cases where you have two fit parents. It can really create some challenges in situations where there is domestic violence. The law does provide for, if there is an incident of domestic violence, the judge is required to make findings about how that impacts the children in making its custody decision. And then if there is also the burden shifting provision that says that it's if it's determined by a preponderance of the evidence that there's a pattern of domestic abuse, and a pattern is key, then you can it's presumed to not be in the best interest of the child to be placed in that environment. But having shared children creates a lot of ancillary issues that can be really challenging to deal with in the context of a summary, quick order of protection process.
And Justice Wood, you are sitting on the Supreme Court, although you serve as a trial court judge and then on the Court of Appeals, but you're dealing with the record that has been provided to you by the trial court. Does that present any problems that those of us who sit on the trial court don't have to deal with?
I think so. And the one thing is, I always say is, if you're making that record in the trial court, the best thing the advice I can give, and I give it to judges, but I also give it to attorneys or anyone representing clients, and especially true in domestic violence cases, is you have to pretend really like everyone in the courtroom's blind. Because that's what's going to happen when it comes up on appeal, because we're just looking at the record. And so, I learned that because I had a case reversed when I was on the trial court by the Court of Appeals. And then the very kind Court of Appeals judge told me to go back and read the record. And I did. And I realized that the things I saw, which was the sort of out of control behavior by a party, did not make it in the record. So the sort of, actually someone pulling their hair out and eating it through the court proceeding, nobody said that on the record. So just things that you're seeing and how someone may be behaving, a perpetrator to a victim, that is happening in the courtroom, just, saying that, hey, I noticed this is happening, or reflecting, or, just by you telling judge, if you could ask the, petitioner not to, act this way, towards the, petitioner while this is going on, and just mentioning that and getting that into the record. If it does come up on appeal, then we are visually, getting that on paper, what you are seeing. So that's the best thing I can think about, is pretend like everybody's blind, and so that it's an audio sort of record of what's going on in the courtroom.
And let me set up the next question by saying this. I went to the 8th Circuit Judicial Conference in Bentonville a few years ago in Rogers. And the Supreme Court Chief Justice Roberts said something that freed me. He said that what happens is lawyers believe that the justices know everything. Lawyers have They believe that we know the law, the judges know the law on every issue. They believe we know the facts and understand the facts on every issue. And he said, Supreme Court justices are not experts on anything. That we rely, and I'm speaking in his language, we rely on you to give us the law, to give us the facts, so that we can use it and do our own research to make a decision. And I have found that that's the same with my job. Most of the things that you bring before me, I didn't practice in that area. And so I'm learning it as you provide it to me. And so don't expect that I know everything you're talking about. Now, Chief Justice Robert freed me to start telling lawyers that. I don't know anything you're talking about. Tell me about it and help me make a decision. Am I wrong,
Yeah.
or am I right?
Well, and sometimes when I was in the trial court, I would say, if you all could just tell me what the elephant in the room is, I could make a really good decision, because I felt like they all knew something, that nobody was telling us.
Yeah, and so don't expect that your lawyers know everything first, and then for the Court of Appeals, make sure you make your record, or for the Supreme Court. If you don't say it or put it into the record, it's not evidence. And so Justice Wood has no way of ruling in your favor if you didn't make your record. And so I just wanted to make that point, but I think that applies in this area because a lot of judges never practice in this area. And so they come to the bench from all types of backgrounds, but not this one. So you have to give us the law and the facts. Now, like I said, the Power Act was adopted to try to encourage people to go into to help out or provide pro bono services in this area. Have either of you noticed any obstacles to obtaining representation faced by victims of domestic abuse? I think the statistics or the Power Act itself says that victims of domestic violence are more likely to receive an order of protection if represented, and that many of the cases or most of the cases that are brought by se plaintiffs or petitioners are denied. First, I'll ask you, Justice Wood, have you seen any obstacles in the place of people needing services or representation?
We have seen it at the appellate court level. So there are not appellants, if they're appealing the denial of receiving an order of protection, they cannot afford representation. If for somehow they did obtain an attorney to represent them at the trial court stage, they certainly don't have enough to proceed with an appeal. But a lot of times they didn't have it below. And if they try to do it pro se and appeal, they're going to get procedurally kicked out because they just can't, overcome the hurdles. And so a lot of that, especially a lot of these cases end up, you saw your presentation that a lot of them were Court of Appeals cases. And it's just really an insurmountable task. And so we see that as an enormous problem on appeals and knowing how to handle it. And so the Supreme Court, if any of you, I don't know if you saw it, but in June, we did announce a pro bono appellate program for the courts. And it's, blessed to work with the Centers for Legal Aid and Arkansas Legal Aid as well. And so if you are interested, you can just reach out to Kyle Burton, who's our tremendous clerk at the Supreme Court. And if you say, I'm interested particularly in domestic violence cases, or whatever type, let him know. And our civil, our criminal cases, they're going to have representation, but the civil cases, which order of protections do not, will. And so you can handle the appeals. A lot of times, the issues of laws are not difficult. It's a lot of times, some fact-based, issues on appeal, but, and then you get the bonus of, you get 3 hours of continuing education credit. How wonderful is that? And then we are encouraging, the Court of Appeals to maybe, grant oral argument in cases of requested, to sort of encourage that if that's wanted. But so thanks for letting me do that plug. But I think that will really, we're trying to help and give young attorneys who maybe want to practice also an avenue, but we really need that representation at the appellate stage of the process.
I was laughing because you were saying that the Supreme Court is encouraging the Court of Appeals to have more oral argument. And I remember Judge Marshall and I went on the Court of Appeals at the same time, and we were telling each other, yeah, I want oral argument. These judges don't allow it and we should have more of it. Then after about 6 months, we said, we're not giving any more oral argument. And so, good luck with that.
I know. But yeah, we're trying, but they wanted the representation. They want representation because you were there. It's better when there's attorneys.
No doubt, no doubt. And Judge Johnson, I'm going to give you another twist on that same question. You know, I mentioned earlier that the act itself says that petitioners are less likely, it actually said more likely when represented, but I'll couch the question this way. Petitioners are less likely to get orders of protection when they're not represented. Have you found that to be the case?
Yes and no. Okay, so I would say that the likelihood of success is largely dependent on whether the petitioner shows. And by the time I see the process, if a petitioner decides to voluntarily dismiss her petition, which a lot of times is, I mean, it happens probably more often than not in domestic violence situations because they are being intimidated, they're being threatened to drop it, and or they're financially dependent. I mean, the other circumstances that just make it impossible for them to get away, they just don't show. And of course, those are not going to be successful. And so I would say absolutely in those situations, because if they've not had the benefit of an attorney who can help them with those other ancillary issues, to make sure that they have access to, they have the mechanism to be able to keep the abuser from moving money around, where they can deal with the custody issues, the ancillary supports that are going to help a victim successfully escape. If that attorney is there at that stage, then I don't think they're nearly going to be as likely to voluntarily dismiss their situation. If they get past the hurdle, if I end up with a victim who shows up, a petitioner who shows up in court and to try her case herself, and I'm using her, I mean, I see the situation flip-flopped a good bit, but just for ease of reference, I'm going to refer to the victim as her. But I do find that if they do come to try their case, even if they are pro se, and that is going to be probably 99% of the time, I mean, they're going to have a pretty good likelihood of success. I will say just statistically, I mean, and again, we don't have the data, but just my own experience is that it is more likely that the respondent is going to be represented than it is that the petitioner will be, in part because there may be a companion criminal case, and it's oftentimes a criminal defense lawyer who's coming to court. And that can make it a bit more of a challenge for a petitioner to successfully put on their case, because they may not have supporting photographs, or they may try to get a police report and the attorney's going to object. And so it is going to be more of a challenge if the respondent is represented by counsel. But so with those caveats, I think that if they make it to court and put on their case, they have a good likelihood, but there are a lot of hurdles to getting there.
And Judge Whatley, have you found the same to be the case? Or would you see it a little different?
Well, my docket is just so different than what Judge Johnson has. But what I can tell you from my perspective, I was just trying to sit here and do some math in my head. I have 2,400 cases on my docket, and around 1,800 of those are what I would call new cases. So they're not revocations or probation. And of those 1,800 cases, I did a calculation, I pulled all of them. I have 242 of those. So about 15% of my docket are cases involving domestic battery, violating of a no contact order, or aggravated assault on a family member. So when you're talking about 15% of the docket, and then being able to have those that end up on probation, a lot of my revocations are because they picked up new domestic charges. So but often I have the victims come in at plea and arraignment, because I give a no contact order at plea and arraignment and again at sentencing for the victims. And it's a lot of times the victim will come in and go, hey, we share custody, or I really need him at home because if he's not home, then there's no one to help me take care of the kids, or I wouldn't have a place to live. So please don't issue a no contact order. And none of those victims are represented by counsel when they come in and ask for that.
None of the victims are.
None of the victims are represented.
I was thinking, like we discussed earlier, the purpose of the Power Act is to encourage people to help the victims of domestic violence. If those victims, if there was a way to appoint counsel or to have pro bono counsel help those victims, do you think they would be more likely to show up and more likely to press their case, for lack of a better word?
I would think so. And I think that having an attorney to be able to explain the process would be helpful, and be able to sit with the victim at the meetings at the prosecuting attorney's office for trial prep, to be able to be in the courtroom so that they have someone that they can look at out there in the courtroom that they know and that they trust. Other than, we have the victim witness coordinators. We have that. All of those people in the prosecutor's office do a great job. But to have someone that knows you're here just for me, I think it would be helpful. And to also be able to explain to them, this is what a no contact order does. This is the benefit to you. I can explain it all day long, but I don't have that relationship with them that an attorney would have with them.
Let me ask you a follow-up to that. We heard from Ms. Stone about all the cases where the Court of Appeals said that there was no cause to issue a protection order. And I know that that's not the area you're dealing with. Do you believe that if someone, well, you're dealing in criminal cases, it would be a little different because that would be something that Judge Johnson would handle. But in a criminal case, before somebody goes down and signs an affidavit to have somebody arrested, if they could at least consult with somebody who would explain to them, okay, this is against the law, that's not, this would be the type of case one order of protection and not to file a criminal case. Do you think that would be helpful?
I do think it would be helpful, because so often they're just going down to the prosecutor's office and they're filing an affidavit, and then a law clerk or someone at the prosecutor's office is having to do some research to determine, does this meet the criteria? And then flipping over to Judge Johnson and things that you deal with when someone comes in for the domestic abuse, being able to say, okay, you don't qualify, you do qualify. And if you don't qualify because you don't meet the parameters of the law, but hey, walk across the street to the prosecutor's office to be able to still file a complaint, but for battery or something that fits more in that statute. So having someone to be able to say, this is the civil side, this is the criminal side, and this is where you need to go would be very helpful.
And I'll boomerang back to you, Judge Johnson. Judge Whatley just dealt with when someone files an affidavit for an arrest. And she said that she believed that having a lawyer that had to explain the person the process and to help them would be helpful. Would that be the same with filing for orders of protection if you had a lawyer on the front end? And I think we heard a little bit from Ms. Stone about that. I think that's what she said. If they have a lawyer on the front end, it helps a lot. Do you see it the same way?
I do. We are very fortunate in Pulaski County, and a number of other counties will have local domestic violence shelters who will have an advocate on site, and we have that in Pulaski County, and that's I'm finding that to be very helpful on several fronts. But because they can assist the victim with safety planning, they can assist them in filling out the petition and answer questions. But in terms of having an attorney who can be their advocate in court to help them present their case and to help, again, with these other ancillary issues, in particular child custody. I just think it would be an immensely helpful asset.
And I'm going to wrap up my questions. So I want to hear from the audience. Are there any questions you have of the judges or justice? But I want to touch on a few things here that deal with the practical side of judging. And it's something that I never could have imagined this before I was appointed to the Court of Appeals and I came over here. As a judge, for the most part, I don't care at all what the result is of the case I'm dealing with. It just does it. Either you presented the evidence or you didn't. But in cases involving the abuse of children, domestic violence, where you have a woman sitting there saying he's beating my behind, and you have the man sitting there looking at you saying, you know, I prosecuted some of those cases. I'm not saying as a district judge, but where you have somebody saying, and I've had a couple revocation cases where I've had hearings where the man says, I just didn't do it. That's not what happened. But I have the woman sitting there saying, oh, yes, you did. And then I have to make a decision. I might not have physical evidence, but I have two competing points of view. When you are faced with that type of decision, and I know I didn't give you, I didn't tell you I was going to answer this question, but help me think through it. What is your process for thinking through how you determine which side is more likely telling the truth than the other? And let me do this. I'm going to take it from the two circuit judges, and I'm going to throw it over to Justice Wood, although she doesn't hear these cases now. When you were trying cases, what type of thought process would you go through in determining which side is more credible in this type of case?
Boy, that's really tough. And I think we've been proven that we think we're really great at judging credibility, but I don't think that we are.
Yeah.
I think we're terrible from every assessment. You know, and we have this sort of, you know, bias that we don't even realize that we have. And so, yeah, I mean, when you're weighing it, it's so hard when if it's just two people's word and there's no other kind of evidence, then it's virtually impossible to find the preponderance of evidence on one side if you don't have something. Usually, you know, there can be enough questions if someone gets on the stand. If you know, if one side gets on the stand, then you get the respondent on the stands. Usually, if you go long enough, you can find an inconsistency, and someone's going to be inconsistent at some point. And then you can be, you know, you got it. Or someone's going to be a little too smooth, you know. And so you just sometimes it's a matter of you know, and you hear both sides, and then you just have to ask you as a judge, ask a couple questions and try to figure it out. But it's really, really hard. And I think that we're trained decision makers. That's really our job, is we're a decision maker, but we're not really trained credibility judges. And so it's just hard. That's why I ran for the appellate court.
And Judge Johnson,
got out of that business.
and I don't mean to put any of us on the spot, because and one of the reasons why I asked the question, because it is that difficult. And there is no computer that you can punch all the information in and it gives you an answer. You're literally sitting there listening and trying to make a decision. What was your process, or what is your process, and when you're trying to determine who's telling the truth and who's not on this type of case?
And it is really hard. And I would say it's made even more difficult by the fact that survivors of domestic violence have experienced trauma, and their recollections of trauma are not going to come out as a sequential narrative. Their behaviors on the stand may otherwise be indicative of being evasive. I mean, someone who's gone through this and gets up on the stand and won't make eye contact, or may fidget, or may have some inconsistencies in their memories, or not remember things in a sequential fashion. A lot of times those are the things that a judge may hold against them in making a credibility determination, without understanding that those are symptoms of trauma. And so I think that presents a real challenge to judges who don't have that experience or training to know that what they are seeing on the stand is someone who is re-experiencing trauma. So I think that is a real challenge. And I think about that, and I make those observations, and I've heard Justice Wood a number of times before talk to attorneys and judges about making your record. And so I try to be careful. I had a hearing that was on Zoom where the respondent was mouthing, "I love you," to the petitioner. He was mouthing it, and I could see it. And so I said that. And If I'm observing behaviors that, if, the respondent trying to make eye contact, I think those kinds of things are going to weigh into my decision about the credibility of the witnesses and the likely truth of the situation. And so I always will throw in there, I'm making a credibility determination here, and I believe the petitioner because of this, and here's what I've observed. And so that's typically, I'm going to be mindful that trauma creates some difficulties in credibility determinations. And then I will usually try to make some sort of record about the reason for the credibility determination. Or if I find the story is equally believable and just can't find by preponderance of the evidence, I'll say that as well.
And Judge Whatley, what's your process?
So my standard obviously is higher than Judge Johnson. They would have to prove it beyond a reasonable doubt. And that makes it hard. Although I will say that so far, I have not had a domestic battery, aggravated assault on a family member case go to trial. They've had some that have gotten close, and if the victim has shown up, they've normally pled guilty. And then if the victim doesn't show up, they a lot of times stand at the lectern knowing that the prosecutor is about to say, Your Honor, we're going to null process this case. And then they sit there like the cat who ate the canary. And that's what hurts when that happens. And so, but it's difficult because it's a high standard, but if the victim will show up, they will normally plead. Then you have, for me, is a little different in that then if they're pleading, a lot of times they don't want to actually admit that they did it. I had a gentleman the other day who pled guilty to aggravated assault on a family member, his father, over the age of 60, and state read the facts, and we're having to talk to them that I need facts, not the law. Don't read me the information. Tell me what he did. And he's like, I didn't do it. I said, okay, fine. Then we'll set this for trial. And he went, well, wait a minute. And I said, tell me what the facts are. And they got to the facts, and it was just, he didn't want to admit that he had hit his 60-plus-year-old father who's in a wheelchair, which caused his father to fall out of the wheelchair and hit his head. He didn't want to have to admit that to his other family members that were sitting in that courtroom. So that's something for the criminal defense lawyers to, so I'm looking at two that are sitting back there in the corner, to have to address, to be able to work with their clients, to be able to say, look, if you did it, you did it. If you didn't, then she'll let you have a trial. But it's just a little bit harder because of my higher burden.
Let me ask this before I get to our first question. Have you ever had a case where you're sitting there, and this is for all three of you, where you're listening to the testimony and it's actually making you a little angry?
Sure.
Where you're getting,
Sure.
and how do you handle when you start getting just a little angry? How do you work through that? Judge Whatley?
I normally take a deep breath, and then I will also, before I make a decision, I will say, we're going to take about a 10-minute break.
Okay.
And I'll go back into chambers, kind of walk through it, because when I want to be very level when I actually get my ruling.
Judge Johnson?
Same thing.
Justice Wood?
Yeah, that's one thing. Now retired Justice Tuck, Annabelle Tuck, told me, she's like, you get to take as many recesses as you want as a judge. And so whenever you need to, feel that. And sometimes you're not angry, but sometimes you're just really sad, and you hear just terrible testimony, and it pulls, emotionally, it's hard to hear that testimony. And when you hear it out of sometimes the children, right? We're not immune from that. And so it's terrible. And so sometimes, we just take a recess because we got to pull it back together. So
I had a domestic violence case involving a son and a mother years ago when I was prosecuting, where the mother got tired of her son going out getting drunk and hanging out all night. So she started praying for him when he came home. And he went and picked her up off the ground, off her knees, and said, don't you pray for me? I'm going to drink and do whatever I want to do. And so the police came out. And I don't know why. I had rape cases of children and all types of other cases, but that really made me angry. But I was the prosecutor, so I could be angry. It's a little different than being the judge. Our first question is, does anyone from the panel know how a petitioner who is limited English, proficient, can file a petition when there is no available staff. And that might be a question for Ms. Stone. You might know that before any of us do. First, does anybody on the panel have that information? Do you know how somebody would file a petition?
I believe, is there a Spanish version of the petition for an order of protection, Jennifer?
Here. Take-
There is though a domestic violence handbook that is in Spanish that is on the AR Courts website. I will disclose, we updated the English version in 2022. It was a collaborative effort by a lot of nonprofits, the Bar Association, but we updated it in 22, but the Spanish version is a little bit behind because we don't have someone to update it, but it's on their website and it's the Spanish version. It's like 42 pages long. So we don't have, I think, the petition, but we do have a tremendous handbook that is in Spanish that is out there.
And also the court has interpreters
Right.
that you can use.
Yeah, any judge will call over and you'll have an interpreter at no cost.
Yes, ma'am.
I don't see Gordon in here right now, but he was talking earlier about the kiosks that are at the courthouse. So that may actually help. And there is a Spanish version and Marshall Lee, they're doing that also with the kiosks that are in the new courthouses. So Jordan may be able to help with access to justice on that.
Anybody else have a question for our panel? Everybody ready to finish up and leave? All right. Let me, before I give our final question or two, any that I have not covered that the judges would like to cover? Judge John?
So I think one of the other challenges and a concern, I mean, I think oftentimes requests will be made for the abusers to attend anger management classes. And I have yet to see any research that shows that that's in any way effective. And it does concern me. I know that we have, I believe they're called batterer intervention programs that are geared more toward therapeutic interventions. I mean, the likelihood that an abuser has themselves been subject to abuse as a child is really quite high. And I'd really love, and maybe we pose this as a question to you all, but I'd really love to see more resources to help in those situations, to provide some sort of meaningful intervention for folks who are perpetrating abuse. I mean, so oftentimes, you know, they're controlling another human being and acting the way that they're acting because of their own trauma and their own issues.
This makes me think of another issue that came up earlier. Justice Wood, we had a question in the last session from a lawyer from Colorado who's now here, who was making the statement that when people violate orders of protection, nothing ever happens. And she was asking, well, what about here in Arkansas? And I wasn't sure about her question, whether her question was here in Arkansas, nothing happens, or whether nothing happened in Colorado. But I'll ask you the question, whether, at least sitting on the Court of Appeal, now the Supreme Court, are you seeing cases where people have been sentenced for violating orders of protection?
Oh, certainly. So yes, definitely. I mean, Pulaski County has an overcrowding issue. So it is county by county whether there's an issue, but depending on I mean, I know judges will call over in Pulaski County to see if there's sort of, room available, but yes, because, and we see it at the Supreme Court because we'll get an emergency writ, challenging the judge's, order, sending someone. And sometimes, some judges are cognizant and will send them to jail on like a weekend to kind of see if that gets their attention. And if not, they'll sentence them to a longer period, but certainly they are I don't think that they're hesitating to enforce it on a violation.
And Judge Johnson, what are you saying?
I mean, I often don't see because the violation is a criminal one, and it's very, very rare that I see a petitioner file a motion for contempt in an underlying order of protection case. And so oftentimes I have no ability to do anything about it as a domestic judge unless there is a companion custody or paternity case where I can enter an order restraining that person from restraining the parties from harassing one another, and then enforce it through my contempt powers there.
Judge Whatley, what are you saying?
So if there's a defendant in my court on one of these charges, aggravated assault, family member, domestic battery, violation of contact order, whatever it is, and they are on bond, and I normally put someone on a bond, even if it's a low bond, I want a bondsman out there and I want some sort of hook for them. Then what will happen is if they violate that, then the prosecutors are filing a motion to revoke bond. And those are the cases that I will revoke the fastest. If they have gone and violated their no contact order. I had a guy the other day, this was super creepy. There was a no contact order. He had gone into her house at night, took a videotape of her sleeping, and then posted that onto social media. And then did not understand why, when he came to court 2 days later, I revoked his bond, and he went and sat in jail at Pulaski County for a few days before we had a bond hearing on him. He was just shocked and amazed that I would do something like that. So we will, and the judges in Pulaski County, yes, we do have an overcrowding problem, but there's always room for one more if that's what they're doing. If they're going out there and harassing the people that have filed these charges against them. And I've got one case where it's the same victim, and he was prosecuted 5 years ago, and then there's another case and another case, or he just moves from victim to victim. And all the judges will revoke their bond fairly quickly on that, or there will be a revocation of probation if they're on probation.
All right, if there are no questions for the panel, I'm going to ask my wrap-up question, and that is simply this. How would each one of you suggest that we promote pro bono services for for victims of domestic violence and sexual assault? Any of you given any thought to that, how we would do that, Judge Whatley?
I mean, I think we do give them some CLE, and I think that's helpful. I think sometimes maybe if you just do it once, you'll realize what a benefit it is to be able to walk someone into court, whether it's criminal, whether it's civil, to be able to just be that person. And even if you're only doing it once a month, I think you'll see the benefit, especially if you come and spend a day in my court. It'll be kind of eye-opening.
And Judge Johnson?
This is a really, I think it's a real challenge. I mean, and part of it, of what we're faced with, is that we really have an attorney shortage in the state, and particularly in rural areas of the state, and getting attorneys who are already working lots of hours to then, take time to do pro bono work. It really is a challenge. I think that the CLE for pro bono rule that the Supreme Court adopted is very helpful. But I think that partnering with local domestic violence shelters, I think that connecting through legal aid, both the legal aid programs that we have in the state are absolutely outstanding. They cover all 75 counties of the state and can provide mentorship and assist private attorneys who want to take these on. I mean, you're not alone. I mean, you've got a resource in our legal aid programs. And I think that those partnerships are really essential.
And Justice Wood, you've already spoken to what the Supreme Court is doing. Is there anything else you want to add?
No, I mean, you can earn up to 3 hours of CLE credit if you're doing any type of pro bono representation. And then the same thing, you get it through the appellate pro bono program as well, 3 hours. I think it's going to be a collaborative effort that the bar has to take it on, different bar associations as well as legal aid. And really, we do have 10,000 attorneys. I mean, if you took a quarter of those and they took on one case, that would just, change the ball game. So I do think if one person here and there takes on a case and they realize the value and then they tell their colleagues that it makes a difference. So.
Well, we just received a second question. And it says, do the judges feel like there are other judges out in the counties of Arkansas that do not support order of protections or do not really like to do orders of protection? So do you know of any, or have you come across those who don't want to issue orders of protection? Judge John?
I don't want to throw any colleagues under the bus. No, I mean, I think that it is a very frustrating process. And I think that there are judges who understandably get frustrated. And in some cases may not understand that when you have victims who file orders of protection, multiple orders of protection over periods of time, and then are consistent no-shows. I think that that's frustrating to judges. And perhaps some of it is they may not recognize that is oftentimes a symptom of the underlying issue with a survivor not being able to escape the situation. I think that there are differences for as many judges as we are. There's many different ways of doing things. And I think that, there may be judges who have different views on what standards of proof need to be met in order for them to consider it a preponderance of the evidence. But I don't know of specific examples, but it is a challenge. I think that they're difficult cases.
And Justice Wood, you're reviewing orders from all over the state, from every county in the state. Have you seen a pattern among some judges that they really would prefer not to issue orders of protection?
No, I think the issue originally was there wasn't a standard order. And so a lot of judges were sort of drafting them on the fly and not, making different lists, and there was inconsistencies and law enforcement didn't know what they looked like and whether it was legit or not. And there was a lot of angst and judges. There used to be, and that was, maybe 2014, 15, 16. And before that there was some tendency of, they're not getting into it. And then once we adopted the standardized form and it was modeled after the surrounding states so that law enforcement would look at it, and it became, it's a checklist basically, and it's real easy to fill out, that judges felt more comfortable. They also felt more confident that the court was going to affirm it on appeal, that they weren't going to find some technical default in the order. And I think at that point that, to me, I feel like judges were totally, fine and had no sort of heartache over it at all. And it's part of their job and they want to protect victims.
I will say this, and I will say this. I had a case once where a man was in Pine Bluff, and it was a revocation case where his girlfriend said that he shot him. He came to court and said, "Judge, I didn't do it." I then said, "Go out," sent the marshal out. I sent them out to serve the woman who claimed that. And she came to court and said he didn't do it. And the witnesses said what happened was she was following him because she had seen him with another woman, and he kept trying to get away from her, and that somebody in his car had a bottle of cologne and threw it and hit her car with it. And I put her on the stand, and she didn't initially just say, "Yes, that's true."
Mm-hmm.
But after talking to her for a while, she said, "Yeah, that's what happened." And so I think judges, at least from my standpoint, I can't speak for these judges, there are implications for
Mhm.
entering an order of protection.
right.
And then you have to weigh it against the implications of not granting one
Mhm.
where you have a person who's being victimized. And I'm just going to tell all of you, that's not easy.
Mhm.
I mean, we really are balancing out what really happened here. And I can change one person's life or maybe both persons' lives by signing one order. And so it's not easy, it's difficult. And so when you have these cases, make sure you bring all the evidence you have to bear, because it makes that decision much easier when you do. I have another question. This is for Judges Whatley and Johnson. And the question is, do you all talk about companion cases? And so, for example, if Judge Whatley has an aggravated assault case on a family member against a defendant who is also a respondent in Judge Johnson's courtroom, do you all ever get together and talk that through?
No.
You know.
Judges never talk.
But, and I don't know, Judge, what Judge Whatley does. I mean, if it comes out in testimony, I mean, I can't go out there and research it and prejudge anything. I mean, but if there's testimony that comes out in court and there's not an objection to it, and I come to find that there's a companion case or a no contact order, then, you know, I may look that up, you know, if that comes into evidence. And so we'll be aware sometimes of those companion cases.
So I may become aware of them, but I would not normally become aware of them until sentencing, or until there's a plea and then there's a sentence. And then normally it is, I will look out and say, why am I not issuing a no contact order in this case? Your Honor, they're going through domestic in front of Judge Johnson, and she has already issued this order. And so then in my order, I just state and follow all orders of Judge Johnson in the companion case. But then I don't pick up the phone and call Judge Johnson and say, hey, this is what I just did.
And to take all of you behind the curtain, especially the person who asked the question, judges speak through our orders.
Mhm.
And so once I rule, then another judge in the building or down the street or across town will look at my order and can use that as a guide. But as far as picking up the phone and asking me, what are you going to do? That almost never happens. And I will tell you this, when I was on the Court of Appeals, Justice Wood, we had one or two people who, when we were going to conference cases, who'd walk down the hallway and start asking about the cases. But for the most part, the judges on the Court of Appeals did not think that was appropriate. But we should conference the cases at the conference and not start trying to talk to each other before the conference. And I bet you that's still the case at the Supreme Court of the Court of Appeals now. You don't have to. No, don't comment on that. But that was my experience there. And so we would speak at the conference when everybody was there and everybody could be heard. But picking up the phone and talking to each other and walking down the hall, we just tried not to do that. Any other questions? Because I think we have exhausted most of our time. I think. Well, no, we have one more.
Question.
Okay.
I guess I'll go ahead and ask. Are there any precautions in place to protect the one attorney from appraisal by defendants and respondents? You don't mind repeating it on the microphone. If there's any precaution in place to protect the one attorney from appraisal by defendants or respondents?
Are there any protections for the pro bono attorneys from an angry defendant, or like, is there any sort of process that the attorney who steps into this can have some protection?
So there has been a case where charges have been filed against someone for behavior towards an attorney. Now, it wasn't a pro bono attorney, but towards an attorney that was representing the other side. And it was swift. It was very swift justice on that. And in the last, like, just 2 years or so, but it was pretty swift. They're an officer of the court. Attorneys are officers of the court. So if they're going to start coming after an attorney, they're coming after an officer of the court.
Anybody else want to speak to that? Or
I mean, I think it just as a matter of best practice. I mean, there's nothing that we as judges can do, you know, absent some sort of request for relief. I mean, there are best practices that we can do to control our courtroom and to control what happens in the immediate aftermath of a hearing. And oftentimes that will include making sure that the petitioner and their attorney are able to safely leave the building and get out before the respondent's allowed to leave. And I think that would be a best practice, but beyond that.
anything else? Which one?
No, I mean, unless they file, like Justice Wood said, unless they file something, and then we would just take it up. But we do the same thing that Judge Johnson does. If I have a very violent defendant who's standing there at the microphone threatening everybody in the courtroom who has anything to do with that case, then we take some extra steps for protection for those people to make sure that that defendant's taken back downstairs through a separate exit and there's no contact.
My only response would be that in my almost 30 years of practicing or judging, I have found that defendants are usually angrier at their own lawyer.
Yeah.
than they are.
Yes.
That's just been my experience. They blame their lawyer. They don't blame the person on the other side for the most part.
Mhm.
And so I would think anybody who is thinking about doing pro bono services for the victim,
Mhm.
you probably will not have
Mhm.
many problems with the respondent or the defendant. If there are no other questions, I'm going to round out the discussion. Judge Logan.
How about a round of applause for our panel? I don't know about you all, but I found this day to be very, very informative, and I very much appreciate our experts on mission here who have provided us very substantive information. Would ask that with this information now in your hands, we've got our partners out in the hall with tables set up. If you would go visit with them and see if there are opportunities to serve and to help the community in these types of cases. That's why we're here today, and we appreciate all of you all participating both online and in person. And lastly, Judge Johnson, it must be a hard thing to leave an organization like the Access to Justice and take the bench, but I can just tell you that whatever you did to establish Jordan and Edith and their abilities, it's just been fantastic. And I would just ask for another round of applause for all their efforts, because they are really the heavy lifters in this effort. Last point, the CLE forms, don't miss out on your opportunity to claim CLE and drop it in the box, and then we'll see you out in the social. Thank you all.